So we first say we're not a public agency, and Blueware specifically asked us not to give these financial documents. So we have them. But if the court finds that the EDC is a public agency and these records are public records, the financial information and client list, then the exemptions would apply. So it's a quite complicated pyramid to get to the ultimate decisions. That's why, in the interest of judicial economy, we believe that the court should look at the attorney's fees issue, and if the court wants to look at those records that we claim are not public, they're financial information.
The attorney's fees issue. They'd have to show unlawful refusal.
Correct, Your Honor. And the case law that we have read says that if you're a private company, even if you're acting as a public agency, you have to unlawfully refuse. And the case law really does not find ever that these private companies have unlawfully refused. Especially the testimony would show EDC relied on the county attorney's opinion and their own legal counsel in withholding those documents. Now they've all been released.
If they were not a public agency, why did they seek legal assistance from the county attorney?
They sent an email to him because
Why would they render legal assistance if they were not a public agency?
I believe the county was put in a position between the clerk and the EDC, and there was the FDLE investigation which prompted the response from Mr. Knox.
Your motion to dismiss.
Record, we don't believe there is an expediency anymore because the records have been produced, except for the financial statements.
The last word you said?
Except
for?
Yes, sir.
That makes it. Except for. So what happened today? Okay. Who's going to do an order on what happened today?
I will, Your Honor.
I find that I have jurisdiction for the reasons asserted in the record. I find the attorney's fees is just an allegation, and we will address that if it's determined there's an unlawful refusal. I denied the motion for alternative writ of mandamus because of this Cochran case. I determined that a public record request under the same Cochran case is appropriate, and I gave 5 days to do that to the plaintiff. And then we were having, within 15 days, briefs/memos on the issue of whether or not the defendant is a public agency, subject to 119. Did I forget anything?
No, Your Honor.
Did she do it run?
The argument sounded as though you're saying EDC is not a public agency. Can you address that?
Well, we're not a public agency. We're no different than every economic development organizations, and we have, legal statute to prove that if necessary. We're a freestanding private 501c6 corporation. But we do want to make sure that, what happened today is we want to make sure that we clear up everything if there's questions about releasing the files and everything like that. This was unsolicited and uninvited by the EDC. We've been progressing with legal counsel and doing everything reflective of the law, so we want to make sure that we clear this up soon so we can get on to do the business we need to do.
Well, if the EDC withholds records or keeps records privately, don't you think that can be damaging? For example, information about what was going on.
No, it's the course of doing business. When we're as a private agency working with private companies dealing with private proprietary information on something as significant and sensitive as a site location, that's why we have statutes to protect that. Thank you very much.
Even after all this time, you think it's still a big deal to have that information out there?
Well, we're bounded by legal authority. That's the reason. We have to release it. They'll be releasable legally within so much time. The time isn't elapsed yet. We have released the records for that fact because we're given the authority by the other attorney. And so we just have to reflect what's available with the law. We can't do what we want to do. We very much, we're not trying to be obstinate. We want to very much work with the law. We want to get this behind us. It's been unsolicited, uninvited by our part. So, yes.
Do you think that having to release records would affect your ability to draw other businesses here if you...
I've said enough. Thank you very much.
All right,
Thank
thanks.
you.
The EDC saying in court today that it's not a public agency. What do you think about that?
I think that was a little bit of a surprise. They had mentioned that during the last week, that they would come in and claim that they're not subject to the Public Records Act of Florida. Obviously, we don't agree with that. In fact, the majority of their funding comes from the county, and it has for over 20 years. They are clearly a public agency, and their records should be subject to public records law.
And when records are withheld, in this case, in the Needleman and Blueware fiasco, what kind of damage can ensue?
Well, the issue is you cannot get to the facts of the matter. We've been trying to get to the bottom of the blueware issue. The EDC's refused to give us any documentation at all. They've always had the option, going all the way back to our first request in January, to give us some of the documents and let us then resolve issues over the final documents. In fact, that was mentioned today, such as financials. Their position since January was that there was nothing there that was a public record. That position shifted this week to the fact that they claim they're no longer subject to public records and never have been.
Yeah.
Very unusual, because even if you look at the county attorney's opinion, it claimed the records were not public because of an ongoing criminal investigation. Now they claim that the records aren't subject to public records at all, which I believe was the judge's point. If none of the records are subject to a 119 request, why do you bother picking here and there?
Yeah, the bottom line is pretty simple, isn't it? The public needs to know what happened here.
Absolutely.
And could you elaborate on
And
that?
quite truthfully, if you are funded by public money, to a large extent, you need to produce those records as public records. Now, obviously, if you're a small company, you take a small amount of money from the county, your books aren't open. In this case, there's an audit clause in the contract with the county that says the records are to be public. There's a clause in the contract with the county that says their records are subject to 119. That's why it was so unusual that they would assert that they're not subject to those records. It's mentioned at least twice in their specific contract with the county.
Yeah, and to almost belabor the obvious, I mean, why do we need to know what's in those records?
Well, as you know, we're going through the ongoing criminal issue with Blueware, and we're going through a civil issue as well with Blueware. We're looking to see what was set up when they came in, because part of our civil case revolves around how did they get hooked up with the clerk of courts in Brevard County? Not just the money, but how did the issue come about? And I believe a lot of that will be found in those EDC records.
Do you think